welcome back to Primetime TV. As I said earlier, we have Avneet Virk with us. Again, Avneet, welcome back. Just before the break, we were talking a little bit about custody. With respect to custody arrangements, you briefly described about sole custody, shared custody, and split custody. And I understand, obviously, that's an area where we could probably have a show on its own. Yeah. You know, a number of factors go into custody, but like you indicated, the key test is the best interest of the child, right? Court ne dekhna jawak waste ki best, right? ਤਾਂ ਜੇ ਇੱਕ parent ਨੂੰ custody ਮਿਲ ਜੇ, ਜਿਹੜਾ ਦੂਜਾ parent ਆ, ਉਹਨਾਂ ਦੇ access ਤਾਂ visitation rights ਕੀ ਹੁੰਦੇ?
So access is a very broad area. Okay. Generally, parents have a duty, the custodial parents, so the parent with custody has a duty to maximize access between the child and the parent. So
the other parent.
Yeah, exactly. Exactly. So if the child is showing some resistance, like I don't want to go and I want to play video games or I want to watch TV, the custodial parent has an obligation to encourage the child to go and see their mom or dad. It also goes for pickups and drop-offs, and just cooperating to make sure that there is that relationship. Now, access can be many different forms. You can have liberal and general access where there aren't really set times, or there could be, where you're maybe have children for a weekend or a midweek, Wednesday after school. There's more fixed term access where maybe it's just one day a week. There's supervised access, which usually applies in cases where there's some sort of violence charges
or allegations.
Or allegations, exactly. Right. Usually.
What is supervised? Where does the supervision take place?
Yeah, so supervised access usually occurs at supervised access centers, and these are publicly funded access centers where there's security, and essentially the custodial parent will go and drop off the child, and the child will meet with dad or mom. Dad or mom can bring a snack.
The other parent,
yeah, the other parent. Yes, sorry, I should clarify. The other parent, the access parent, and the access parent can bring them gifts or meal, and they'll sit and they can play and connect in that room.
Is there any cost or koi kharch hunda?
Yes, there usually is. Without getting too detailed into it, because it varies from place to place, there is a cost, but it's not prohibitive. So, and I definitely say it's worth the fee for having to see your child. There's also usually supervised access comes into play when there's domestic violence charges or allegations, and usually it's the starting point. There can actually be no access as well in very serious cases or child endangerment where the court says no, like this is not a good idea. But usually the goal is to always graduate from supervised access into open access. And usually moving from an institution, you can go and say, okay, with a third party. That can also be considered a form of supervised access. So a third party can be a mutually trusted friend. It could be a grandparent that has a good relationship with both individuals, that's be able to de-escalate the violence and conflict, or they kind of are a neutral source and have a good relationship. But it is a lot.
Just talking about the domestic violence context in relation to family law, I think we get these cases almost routinely. Yeah. I've had concerns from one parent or another parent that when the child comes home, they say various things, or the other parent is putting the child up to saying various things. I think these supervised centers also give some comfort to the parent that's actually having access if they're being accused of doing something inappropriate, because as you said, there's security there, there's supervision, and basically what's happening is done in public.
Yeah, exactly. And the benefit of supervised access too is that you have a third-party observer present, and they can actually take notes and observe the interactions between the children or child and the access parent, and sometimes those notes prove very useful in expanding access.
Do they give those notes to the courts, or
yes,
do they give them to the lawyers? Or?
So you have to. It's a bit there's a bit of paperwork behind it.
Right.
You need to be able to have an authority to release the records, and that means you need the consent of both parents,
Right.
because you're dealing with a minor. So, but usually there's no reason why a court wouldn't say, yeah, I'm fine with this order, because at the end of the day, it goes back to the custodial parent's obligation to facilitate maximum contact with the child.
Again, just keeping with this point, because
Yeah.
we get a number of calls with respect to access and supervision.
Yeah.
If the custodial parent, they are to take the child on, say, a Friday,
Yes.
which is part of an order from the court, and they refuse to do so.
Yes.
You know, a number of the family lawyers at our office and yourself, I'm sure, have received that call at 5 o'clock or at 6 o'clock on Friday evening saying, you know, my husband was supposed to drop off the child, or my wife was supposed to drop off the child, and she's refusing to do so. What do you do then?
So the goal is to remain calm.
Right.
Look at your court order, look at your agreement. If there's none in place, obviously it's a bit more complex. Note the date and time.
No, if there is a court order.
Yeah, exactly. Look at, note what your court order says.
Yes.
Right. Look back to it. Sometimes it's a bit of frustration, but know what your parameters are, and then note the date and time of the missed visit.
Okay.
Keep a track record.
Like
If it's once, I mean,
Things
sometimes events happen that are outside of the control of both parties. And usually a lawyer would say, depending on the extent of the infraction, so if it's like they missed an entire Christmas break with you, that's one thing, but if it's just a weekend, then usually it's permissible. But if there's a pattern that starts to form, it's definitely something to raise with your lawyer and also with the court, because if the custodial parent is withholding the child from you and you have rights, then they're not actually acting in accordance with the child's best interests, which is the test. And that means, in some cases, you have to look at revisiting who has the custodial and access relationship. Maybe the court may order, okay, mom is really withholding the children so much against dad, and I use mom and dad because it's the stereotypical relationship,
right.
But it could go both ways.
Right.
And find that, you know what, maybe you're taking advantage of this custody arrangement that you have right now, and we're going to switch it up. Not every case, but it has happened.
Let's talk about this example here.
Yeah.
Mom has custody,
Yeah.
and every weekend dad has access.
Yes.
Say Friday to Sunday.
Yeah.
And over the course of 3 months, the mom has, for one reason or another, refused to send the children to dad, say 8 or 10 times out of 12
That's a lot.
weeks.
Yeah.
Are you then saying that the person who was supposed to have access, say the father in this scenario, can go to court and ask for some type of new order?
Well, there's certain parameters. One other avenue you can do, and I don't recommend it because courts treat it very seriously, is a contempt motion.
Okay.
And you need a lot of intentional disregard for court orders, a lot of facts, to basically have the court find that person in contempt of court. And the court can make a bunch of different orders, right, as they see fit in that situation, whether it's fining the person, putting them in jail, although very, very extreme. It has happened. Right. I'm talking extreme examples here for people who actually take it to court to further their case. The other option is to do a motion to change, but you definitely have certain restrictions. You can't bring a motion to change within 6 months of the original order unless there's certain timelines there. And even then, it's a huge, huge undertaking, right? Legal expense wise and all the other things that you have to consider. But at the end, if it is your honest and genuine opinion, backed by a legal opinion, of course, where a lawyer will go through you and say, okay, I think you have a case here for variation. It's not automatic. They have to look at your background. They have to look at what facts existed when the previous court order or separation agreement was made, and has there been a change in facts? So it's not so straightforward, and that goes back to seeing a lawyer and getting advice on whether you have a case for what we call it variation. Yeah.
Example, husband, wife,
Yeah.
they were married for a number of years, they decided to go their separate ways. Both parties reside in Toronto.
Yes.
Custody is with mom, and mom decides that she wants to move to Vancouver. Job opportunity.
Okay.
Or the kids' maternal grandparents are in British Columbia. Can she just pick up and leave with the kids?
So the law definitely discourages it if there's no court order or a separation agreement in place. So say if you're just going on an informal basis, which a lot of people do when they separate, sometimes in the first few months, you're not because of the difficulty emotionally of what you're going through. Many people are not straight to go to lawyers and right away.
Right.
So they technically and legally separate. So it depends on what stage you're at. But most court orders that I've seen these days, and even most separation agreements, which are agreements that two parties come into by agreement with the work of lawyers usually, have restrictions on mobility. So the usual clauses, well, you can't move outside 30 kilometers of the region of
GTA
Peel or
right.
Caledon or wherever you are, because there's an interest on keeping the child within the community that they were born and raised and where they go to school and where their friends are, where their mom and dad are. But at the same time, life events happen, right? Sometimes someone has a new husband or they get an amazing job opportunity. And then those are the most difficult cases in family law, because then your option is, if the other party is not going to agree to the move or consent to the move, you have no option but to go to court, to ask the court to give you an answer.
Give you permission to do so, right?
Exactly. And even then, the court requires evidence. So usually, and I'll get into this a bit more, but there is government appointed individual in an agency, essentially the Ontario Children's Lawyer, which can sometimes provide you with a recommendation. They can provide recommendations on actually custody and access in general, even if there's not a move-related piece to it. But
the Ontario Children's Lawyer.
Yes, exactly.
Who do they represent? The children?
So the Ontario Children's Lawyer acts for the benefit of the children. So in some cases they represent them, but they're just acting in their interest, sort of like a public interest.
Who hires those lawyers? Does the court appoint them, or how do they get involved in a case?
Okay, so usually at the first or second court appearance in front of a judge where there's a custody access or move-related issues concerning children, the court may say, you're saying one thing, she's saying another thing. I'm going to appoint the Ontario Children's Lawyer to provide a report with recommendations with respect to what is best for the child at this point in time.
Okay.
Now, the Ontario Children's Lawyer has discretion to accept the judge's order to be appointed, but they can also decline. And given that's more tied to budget constraints, but the Ontario Children's Lawyer won't always say, yes, we will take on your file. But if they do, and depending on the age of the child and where they're geographically located, they can appoint a clinician. So I'll go into this further. So what a clinician does is they can essentially provide a custody and access recommendation. And they can also look at the psychological, behavioral factors that are involved in a relationship. They're very in tune to, okay, is mom and dad, are they letting their bad communication affect the children?
Right.
They are medically and they have their psychological training in this regard. So they're much better at digging deep into those issues that a court may not necessarily be able to see because of limited resources. A judge doesn't have 10 hours to go back and forth. They like to read a report.
They don't have the experience.
Yeah, exactly.
These are people that
are
trained.
Yeah, and they take hours and hours to prepare, and then they put into a report. Now the thing is, the report, while it's evidence and people frequently rely on it, a judge doesn't have to follow it.
Okay.
It's just a recommendation. So it's not always binding, but they are persuasive in certain circumstances, and there's also ways to challenge it as well.
Avneet, I've received calls and I've heard from various individuals that they've either had or they've been threatened or warned that if they don't make their support obligations, then their driver's license or their passport could possibly be suspended. Is that the case? Can you tell us and explain that?
I'll back up a bit here. So once a court order and separation agreement is made, so once both of you have come, there is a finality to your situation, your agreement or your court order can be filed with the court for FRO enforcement. So the Family Responsibility Office will enforce only support for the child, or if there's spousal support for your spouse or your ex-spouse. And essentially, it's a good mechanism as well, because if you're paying through the agency, they keep a track record of all your payments, so you don't have to keep every single e-transfer receipt or cash. If you're making cash payments, hard to track to your spouse. So this is kind of like a uniform system to keep track of your payments. If in the event someone says, "Oh well, I didn't, you didn't pay me."
You gave that example when we talked about that individual earning $52,000. There's 2 kids and $798 a month in support.
Yeah.
Now, the individual that has to make that payment, the support obligation, does he make that payment to the FRO, or does he usually make it to the spouse, the ex-spouse?
So I think it's around 66% of cases are enforced through FRO. So they're automatically enforced if it's a court order, unless you withdraw them. In most cases now, more and more cases are going there.
Does it cost anything to any of the parties?
It doesn't cost anything, and in fact, if you're a support recipient especially, you should be insisting on it. But now it's basically like a standard form clause that you have in a court order. And so what that pair can do, and if you're really good with your payments, is it's still good to put it through them, because there's a benefit to you.
There's a
exactly,
record,
there's a record.
Right? An accounting for it,
And also what FRO does is, if you're forgetful, they can send a deduction notice to your employer. So if you're, not for self-employed individuals, but if you're an employee in a company, then they can send an income source deduction notice to your employer, and the employer can automatically take the child support payment from your paycheck.
Is that a garnishment?
It's a garnishment, essentially, and as soon as they file a court order, it's automatic, and it's a pretty scary but valid power that the government agency has to basically make sure support payments are made. Now, you spoke earlier about the driver's license suspension.
Yes.
So what happens when you stop paying support, or you make some partial payments, or you fall behind? Well, FRO essentially has a number of different mechanisms available to them to enforce the unpaid amount. So they can start off with taking your income tax return. If you don't, you get your return every year, you file your taxes, they can take 100% of it and submit it to the recipient. 50% of your employment insurance payments if you're unemployed. CPP deductions, all of that, it can go directly to FRO, and because FRO and the FRO is part of the Ontario government, but they have an agreement with the federal government, so they can pass off. The federal government will pass on the money to the Ontario government, and then they in turn will pay the recipient. And then what happens is, if it reaches a certain point, they'll start being more aggressive. So then they can suspend your passport, they can suspend your driver's license, garnish your lottery winnings if you're lucky enough to win a lottery, and also in very, very intense cases or dire cases, they can even ask the judge to commit you to jail. So
suppose someone needs a driver's license for employment purposes.
Yeah,
we have a number of individuals that drive trucks or have cab licenses. By taking away their driver's license, that really isn't going to assist them in making any payments, is it?
Exactly, and it's not. So your best interest is either to, I mean, when you're first served with that driver's license notice, you have a period of 30 days to bring a court action to try and stop the FRO from suspending it. So when you get that driver's license notice, you have a very short window of time
So it's
go
not
and see a
automatic?
lawyer. It's not automatic because
can-
it's still there's still rights and balancing and all that,
So
right?
you can go to the court and have them basically stay that order?
Yeah, a
Okay.
refraining order. It's called a refraining order. But I mean, it comes. There's a test for it. So they look at your payment history historically.
Right.
They look at if you have a case for variation. So why aren't you paying? Is it because you lost your job? Well, that's probably more legitimate. But you just didn't want to pay anymore? Probably not so legitimate. So you have to come to the court with clean hands. You have to come to the court genuine and not with any ill intent. And the court then will decide if you get a period where you may make certain payments that are lower than your usual amount, or they may say, okay, pay your amount and then pay off 100 towards the arrears. But this is getting into a lot of detail, but you also, a condition of that is also bringing a motion to change. Remember what we discussed earlier when something changes, say their custody or access, so you basically have to bring a motion to change to say, okay, now my circumstances have changed. I need to lower my support amount because of 1, 2, 3, and 4. So it gets very, very complex, and usually if it's a small amount of arrears, you may want to consider, it depends on the facts. Once again, the reasons why you're exactly. So I won't give you a hard yes or no on what's the best approach, but the driver's license suspensions are very real, and there's a short timeline for replying. So go and see a lawyer quick about how to deal with that, or call FRO and work out a payment plan. And they can usually do that even after the 30 days expired. But usually they require that you pay your child support amount at the very minimum. And then some amount towards the arrears.
I know we've been talking about custody and child support, and you've talked about the best interest of the child and the fact that the court looks at that primarily. Is there some age, at some point, when a court thinks that a child is old enough to decide where they want to stay, or which parent they want to go and live with?
So with very young children, it's a no, because courts are very in tune to the fact that parents can have an influence on their children, and that parents may mean well, but it doesn't always show in the right way when you're dealing with children. However, I've seen more and more, probably around 15, 16 years old, they're entitled to more respect. Their preferences are given more weight.
Right.
And when I go back to the best interest of the child test, there's like 10, 11 different factors, maybe less, and that's one of the factors. So it's given more weight with perhaps older children.
As the child gets more older, I guess the maturity of the child is looked at.
Exactly. And also, it once again goes back to goes back to the family history. How have mom and dad historically been with each other? Have they ever talked in a way to influence their children? If there's a lack of evidence about influence, you may have a better argument to say, well, okay, they're 12, can we take into account their preferences? It's becoming more and more common. There's a shift happening in lowering that age, but it's still like a new area here in terms of at what age specifically it's okay to do so.
I know the law is always evolving, and there's always different cases that are coming out. What about the rights of grandparents?
Okay.
Do they have any rights to access to their grandchildren?
So there's actually been recent amendments to expand grandparent rights.
Okay.
I've had experiences where both parents have been declared unfit to parent, and maybe there's a history of drug abuse or violence, and they're violent against each other, and the child is present, that the court says, well, the next person who has the best interests of the child in mind is grandmother. However, biological parents still have a preferable position in the law because they are custody and access, because
let's say the grandparent wants to see their grandchild once a month.
Okay.
Can they go to court and say, we would like to see little Billy or little Sandy one day a month? Exactly. Can they have some type of application?
They could. There is an opening for it, but as I've said before, the views of the custodial and access parents are entitled to great respect. So if there's a legitimate reason why this facilitation of access is not happening, it's a new area. Like, there's the cases on this one, I think there's maybe one or two, and it's still, even though symbolically, yes, grandparent rights are now being recognized, they still have a long way to go before it's an affirmative, okay, it's a definite slam dunk that you're going to be able to carve out fixed access time with your grandchild, because obviously there's already two parties sharing time here, right? It gets complicated when you're instilling more individuals in the picture. But of course, at the end of the day, part of the best interest of the child test is looking at relationships with their grandparents. So if they are close to their grandparents, arguably it's something to be said that they should be seeing their grandparents, because that would be beneficial to them. To
the children, absolutely, absolutely. Let's say there's a number of children of a marriage, and after a separation and divorce, do the courts try and keep the siblings together, or have you seen cases in which one parent may have a child and the other parent may have custody of the other child?
Yeah, of course. So definitely there's another general principles always that I'm speaking in terms of, but the general principle is to try and keep siblings together, especially if there's a close affinity and affection between the children. However, in some cases, split custody does work. Maybe if there's an age difference, usually if one child is 4 and the other is 14, and maybe that connection is not as strong, or maybe they're able to work in a split custody arrangement where it's 3 days you switch over and there's some common time in between or some overlap. I've seen that as well. So split custody is definitely not as common. Definitely I've seen more primary residence, which is custody, and access and shared custody.
Right. Every case is case specific.
Yes.
Ebony, you won't believe we've almost come to the conclusion of our show today. I want to thank you very much for coming out and sharing your knowledge of family law with our viewers. This is our goal here in partnership with Primetime to help our viewers understand different areas of law. Why don't you give the viewers your contact information and what your hours are and how they can best reach you?
Of course. So I'm usually available for a 30-minute free consultation. You can reach me at 905-451-6610, and I should be able to assist you in your family law matter.
Again, ਸਾਰੇ ਆਪਣੇ viewers ਨੂੰ thank you. ਅੱਜ ਸਾਡੇ ਨਾਲ ਅਵਨੀਤ ਵਰਕ ਪ੍ਰੋ ਸਟੇਸ਼ਨ ਕਰਾਊਚ ਵੱਲੋਂ ਆਈ ਸੀਗੀ। ਜਿੱਦਾਂ ਅਸੀਂ ਅੱਗੇ ਦੱਸਿਆ, ਸਾਡੀ firm centrally located at downtown Brampton, Queen and George Street. Our hours are Monday to Friday, 8 to 5:30 p.m. And our contact information is 905-451-6610. Thank you very much.